Hello, I'm Anne Marie Gattari, your host for Aging Well in America. Every day, up to 10,000 people turn 65 years old in America. 5.5 million people are aged 85 or older. By the year 2050, that number will grow to 20. 20 million people will be aged 85 or older. Are we ready? Is America ready? There's so much good work going on around the country, around our own community right here. And we have with us today someone who's doing some of that good work, Jeffrey Bruss. Jeffrey is an attorney who works with families who are planning their futures, planning their parents' estates and their end-of-life decisions. And we welcome you, Jeffrey. Thank you for joining us.
Well, thank you, Anne Marie. It's great to be here. I'm excited to talk to you today about this.
Great. Before we start, Jeffrey, tell us your firm and where it's located. And we'll put there's your information, Stewart and Bruss, and where is your firm located?
We're in Clinton Township. It's Stewart and Bruss, PC, and we've been in Clinton Township for a long time. Mm-hmm. The senior partner in our firm has been practicing for almost 50 years. His name is Wayne Stewart, and his partner is Janet Bruss, and that is my mother.
Oh,
so
very good.
I work for Wayne and my mom, Janet.
Wonderful.
And then Wayne's daughter, Jill, works with us as well.
Okay.
And then we have some other attorneys in the office.
Okay. So it's a fairly small firm?
Kind of fairly small.
Family feel?
Yeah, kind of a family feel, definitely. We pride ourselves on that and making people feel very, very comfortable. We like to get our clients on a first-name basis with us, and we get on a first-name basis with them. We like to make it as comfortable as possible because sometimes the things that we're talking about can be uncomfortable.
Exactly, and that's what I was just going to ask. So we were talking before we came and sat down here about the advance directive. That's often a term that's used to refer to a lot of different legal documents that are used in someone's later years. But I'm not sure we all understand exactly what an advance directive is. So take us through that, please.
It can definitely be confusing, and the words kind of get thrown around and mixed together, and people just kind of lump all these documents into one and don't really know exactly what they are. But typically in the industry, advance directives is a term that encompasses documents that go into action, if you will, once a person has become incompetent or unable to act on their own.
Okay.
So in our office, we label advance directives as 3 documents, basically.
Okay.
A general durable power of attorney that we typically draft as being immediately effective, and I can tell you more about that.
Okay.
A patient advocate form, and a HIPAA document.
Okay, and HIPAA, of course, is the Healthcare Privacy Act.
It's a relatively recent document.
Right, okay. All right, so take us through each of those individually.
The way that we describe it to our clients is that the general durable power of attorney is basically for financial matters, real estate, bank accounts, Social Security, things like that. And what it is our client will be the person that is designating someone else as an agent that can act on their behalf if they're unable to do so themselves.
Okay.
Sort of the scenario that a lot of estate planning attorneys use with these types of documents is, and we refer to mom and dad and son and daughter typically. So mom's unfortunately in a car accident and she's become comatose and she's unable to, withdraw money from her bank account or things like that. And she can designate an agent who can do that. So even if she's not designated her son or daughter as a co-owner on her account, if in this document she's designated her son or daughter to be her agent, they can go in and get information about what her balance is, potentially withdraw money if bills need to be paid, things like that.
So it's not necessary then to become a co-signer on checking accounts and saving accounts, or because I know a lot of families do that also.
And that is something that a lot of families do, and sometimes you want to be hesitant with that because when you put somebody on an account, they become an owner of that account.
Right.
So it's an easy step for people to do. However, it can cause complications down the road sometimes because that account can become an asset of that person that you're putting on that account.
Oh, I see. Okay.
So with the power of attorney document, we give those extreme examples of an accident where somebody's become comatose, but also even if it's something less severe than that, like their health is failing, or if they begin to become more mentally incompetent, like they can't pay their bills anymore, things like that. This power of attorney document can come in and basically, again, be shown as proof to whatever agency is asking for proof that son or daughter can act on mom's behalf.
Yeah, so I'm just going to take you back to my family situation. My sister was a co-signer with my mom after my dad passed. My sister was my mom's checking account had my sister and my mom's name on it, and so she paid all my mom's bills. But I had the power of attorney, so I had to show the legal documents to conduct any business on my mom's behalf, but my sister Rita just wrote checks and paid bills. So I can see what you mean by there being some complications. Luckily, in our case, there were none, but the assets were pretty much paid down to pay for her funeral and so forth. But the durable power of attorney, if the person has those documents, can go in and write those checks on her behalf, etc.
Yes, and our document that we have, it's a document that we've added to and used for many years.
Okay.
So we line item address all these different scenarios, like being able to contact Social Security if necessary, having real estate powers. So if mom becomes disabled, son or daughter can step in and actually attend closings and sign on behalf of mom or dad to sell real estate.
Is there a difference between durable power of attorney and medical power of attorney?
Absolutely.
Okay.
Absolutely. Those are two completely different documents, and the laws of Michigan, the statutes, are completely different as well. So you hear people talk about medical powers of attorney. You hear people talk about patient advocate forms. You hear power of attorney for medical reasons. All those terms are kind of interchangeable.
Okay, so the patient advocate form that you spoke about up front, that's basically the medical power of attorney.
Yes.
Okay.
And that's the document that essentially gives the same type of agency power to someone. Again, we're talking about mom or dad, so mom can designate that son or daughter is their agent in situations where mom cannot make a decision on her own behalf, and that son or daughter would have to step in and make that decision.
Okay. Now, what happens when there's a disagreement on what that medical treatment should be? Does the person who is the patient advocate, does that person trump everybody else?
Typically, yes.
Legally?
Legally, yes.
Yeah.
And it's definitely important for anyone to have these documents, but especially when there's situations where people have non-traditional families.
Yes.
So a second or third marriage, or a longtime girlfriend or boyfriend that they've not gotten married. But we see this a lot as people grow older and they lose their spouses. They'll get boyfriend or girlfriend, which is great. And when you have some of these non-traditional situations, that's when things can tend to be testy between family members. So it's great when someone can kind of avoid that for their family by making it clear in documents. I want my son to make this decision, or I want the new love of my life, whoever her name is, to make this decision on my behalf, so that they're not feuding amongst each other to decide that. They can look to the document and see, okay, dad wanted,
Yeah, because absence of that document, if it's a second or third spouse, the spouse makes the decision over the children. Is that correct? If they're married.
Well, that's sort of the issue, is that if mom or dad has, let's say mom, if mom has become incapacitated, and if there is no document like this, technically, pursuant to the law, nobody now can make these decisions on mom or dad's behalf. And when we talk about decisions like this, we're talking about things like mom's been, 911's been called, mom's gone to the emergency room, and a decision needs to be made about whether or not they're going to put her on a ventilator.
Right.
Okay. And if there's no document in place, If no patient advocate or medical health care document in place, then you're basically leaving this in the discretion of the doctors. And typically they're going to err on the side of trying to keep a person alive.
Right, exactly.
So, and especially as people get older and more frail, you can put someone through a lot of trauma and turmoil at an end stage of their life when typically they may not have a quality of life after these.
And that may not be what they want.
Exactly.
And they've expressed it verbally, for years and years, but again, it wasn't put in a legal document.
Right.
So, okay. So the situation of a non-traditional family is especially important to have these documents in place. And,
absolutely.
And again, if you look at it from the parent doing their family a big favor by having these documents drawn up and making sure everybody understands what they want and what they do not want and who they want acting on their behalf can save a lot of pain.
Absolutely. It's a great thing for people to do for their families by taking the time to create documents like this.
Yes. And then the third one, the HIPAA, the healthcare privacy document, what does that entail?
That's a simpler document, if you will, and basically hospitals cannot share private health information with people unless that person that's being treated has authorized the hospital to release that information to their son or daughter or wife or whomever.
Okay.
So the HIPAA document is basically a document that says, I, Dad, am allowing whatever the treating medical facility is to release information to son, daughter, wife, whomever. And that's a relatively recent document. So we see a lot of people that will come in, clients that we've had for a long, long time that haven't been in 10, 15 years, and they won't have that document because it's relatively recent.
I see.
So that's something that if you've gotten estate planning done in the past, but it's been a while since you've seen your attorney, that's something that you may want to add. Additionally, there's been some other updates in the law pursuant to the patient advocate form and the general durable power of attorney, and specifically regarding acceptances of that power. So if you designate a person as your agent in a power of attorney or as your agent in a patient advocate form, they have to accept that power. And as far as the power of attorney goes, that acceptance was just required about 1.5 years ago.
Oh, okay. All right. You don't want to give somebody an assignment who's not going to carry it out on your behalf. Okay. What about a DNR, do not resuscitate?
That's a separate document. Now, typically in our patient advocate forms that we draft, the agent that's getting designated does have the power, if you will, to tell a doctor, do not resuscitate my mom, my dad. However, that it is a separate document if you do want to have a DNR in place.
Okay.
That would be, when I talked about the advanced directives and I said those 3 documents, a DNR in our office would be a 4th document. And it would be a document that would just say that, if medical provider is called to our house, EMS, something like that, I do not want them to take extreme life-saving measures.
Okay.
It's the type of thing that you definitely want to, there's bracelets that people will wear that will say, I have a DNR. Typically when people start getting up, older in age and they have health concerns, they'll actually post it on the back of their door in their house. And EMS are trained to, look for these types of things when they come into the house.
Right. Why is that so important? What can happen if you do not have a DNR, or you have one but it's not expressed and not carried out?
Well, what could happen is, many times what we've seen in our office is people will express things like that if they get to a point that their health is failing and they're in their home, they'd rather pass peacefully in their home. And the people in the medical field, there's so many advances and there's so many great things that they can do, and there's so many times that they can revive people or sustain life.
Right.
However, unfortunately, it can only be for certain amounts of time.
Right.
and these problems that elderly people typically get, they become too much for the doctors to handle.
Right.
So you see these situations where they have sustained life for 2-3 weeks in a hospital, and they're on ventilators, and people don't want to live their last couple weeks like that.
Right.
They'd rather pass in their home.
Exactly.
So if that's how you feel, and if that's strongly how you feel, that you would like to pass peacefully in your home, a DNR is very important, because the EMS will come in and they'll be obligated to save your life. And that type of stretched out situation, like I said, that can be very traumatic on the person, on the family, will eventually happen if you don't have a document like that.
Exactly, yeah. That was, again, a situation that we faced, and we made it very clear there were a lot of people around my dad when he passed in his home, a lot of family members, and we had to make it clear to whomever was there kind of on duty at the time that they knew. Also, caregiving staffs, that he was not to be resuscitated, because that was his one fear. A lot of people have a fear of that they will be, like you said, sustained almost artificially.
And almost in a vegetative state, in an unfamiliar setting, in a hospital.
Right.
So it's great that your dad, took that step to make sure that his wishes were carried out and that your family could be there with him.
Yeah, it was. I called it big.
Yeah.
Helping a parent die, and that's what my siblings and I did, was a big event in our lives, and one that we felt privileged to have been able to do, quite frankly.
I'm glad that it's difficult. It's obviously difficult, but I'm glad that you're able to get through it like that.
Yeah, absolutely, having all of that in place. So there are a couple of other things, too, and it seems like there was a time when a will would have addressed all of these issues. Why is that not enough right now?
Well, when we talk about advance directives, those are documents that grant people power while the person that's granting the power is still alive.
Okay.
So as soon as, if you have a power of attorney or patient advocate form in place, as soon as that person passes, those documents have now become null and void.
Got it. Okay.
So the person that's been appointed in the power of attorney can't go into the bank and say, okay, Mom had some money in a bank account. I'd like to get that out now so I can give it to me and my brother and sister.
Right.
Because that document is null and void upon the passing. So that's when a will or a trust comes into play.
Okay. Got it.
And those are documents that distribute, typically distribute assets or things like that to the heirs or beneficiaries pursuant to whatever the instructions are that the person that's writing the document.
Okay. All right. And the trust?
The trust is the trust and the will are different in that a will it gives those directions about I want the house to be sold and split in thirds amongst my 3 children or whatever, but a will needs to be probated. Okay, that's an extra step, if you will. You actually have to physically take that original will, go down to the probate court, file it along with a petition to become personal representative. There's additional steps there. Okay. And then that process is going to be overseen by a probate court judge. Whereas a trust, one of the nice things about a trust is that a trust allows assets to be passed outside of the probate court.
Oh, okay.
So potentially we can sell real estate without having to go to the probate court. We can divide bank accounts amongst beneficiaries, pursuant to the trust instructions. And that's a big, big difference.
Yeah.
Typically, we, 99 out of 100 times, if applicable to the client, will recommend that you get a trust to avoid that probate process. And probate has its place, no doubt about that. But the nice thing with a trust is that when we draft it, we become familiar with the mom or dad that's drafting the trust. We become familiar with their assets. And now when son or daughter have lost mom and dad, we can serve as a point of reference for them as what the assets were, how they wanted them distributed them, and help them through that process.
Right.
And unfortunately, the probate court, they legally cannot help you through that process. They're going to tell you that you have to go get an attorney. An attorney, quite frankly, is probably going to charge more to administer a probate estate with a will as opposed to administering a trust estate.
So it sounds like you would almost always recommend with a will there be a trust.
I'd say almost always. It's definitely case specific.
When would a trust not be appropriate?
A trust would not be appropriate if potentially we can have all of our clients' assets passed by way of operation of law. Operation of law being beneficiary designations on bank accounts or IRAs or things like that.
Okay.
If it's a relatively small family, we can make sure that. And what we'll do is the process sort of all starts the same. We have the client come in, we get full disclosure of what their assets are, and if they don't have real estate or if they have bank accounts that we can just put beneficiary designations on, we'll just ensure that those steps have been taken, and then we may not draft a will or trust at all for them.
Okay, because there's a named beneficiary on each of the individual assets.
Exactly.
So that is going to be passed naturally anyway.
Exactly.
So the whole package of, and I know this is all under the umbrella of estate planning, is that correct?
Yes.
Okay. What's the time frame? What does it take, or how much time does it take from beginning to end to get all these documents in place, and roughly what's the cost?
Well, probably a lot of the work and time, if you will, is on our actual client to gather information.
Okay.
It's sort of like, if our clients can think back to when they bought that first house and you got to gather tax returns and, bank account statements and things like that. It's like that. We need a comprehensive look. We typically ask for 2 years tax returns, all account statements from any bank accounts, brokerage accounts, etc., real estate documents, life insurance policies, things like that. We need all those documents. So we send out a list of those documents to our clients so that they can gather them and then bring them in for our meeting.
Okay.
Once we meet with the client, it doesn't take too long, depending on what their situation is, 2 to 4 weeks to actually turn around and get those documents ready for them to sign. And then it's definitely, it's hard to say what the cost will be. We do have typical costs of a marital trust costing $1,500. I'm sorry, a marital estate plan costing $1,500, and a single estate plan costing $1,250.
Okay.
But potentially on what the client needs, we may adjust that up or down. But that when I say those prices, that does include a revocable living trust, what we call a pour-over will, and the advanced directive documents that we discussed earlier.
A pour-over will?
Yeah, that's...
What's that? You knew that wasn't going to get by us.
It's kind of a complicated thing to explain, but one of the things that's so important about having a trust, okay, and having a trust is making sure that we can have all these assets pass outside of the probate court. One of the most important things is that trust be funded, okay? So typically we'll have a client still own their bank account in their name, but the actual trust will be the contingent beneficiary as opposed to son and daughter. So that's that extra step of funding a trust, making sure that the trust becomes the owner of these assets upon the person's passing.
Okay.
Now, every once in a while, a client will forget about a little brokerage account that they had, or stock certificates, they didn't bring them in, or they'll forget that they were on a piece of property with their brother or something like that.
Right.
So if one of these assets gets missed in the funding process to the trust, a pour-over will that we draft typically says that this asset that now needs to be probated because it wasn't funded to the trust, goes to the trust and gets distributed pursuant to the trust instructions.
Okay, so it's basically a big umbrella that says anything this person owns, whether or not it's listed, is included.
Yes.
Is to be included. Okay. That brings me to something that I just came across. There's, as you know, people who are owed money, and they may have forgotten about a policy or a refund. I just read in AARP magazine. You can go to a website called missingmoney.com and just put your name in and see if there's anything out there. Well, I just found my dad is owed some money. Well, he passed away almost 4 years ago. So very simple form I have to fill out and get it notarized and send in a copy of his death certificate and the obit to show that I'm his daughter, I'm his heir, and we'll be able to collect that. The amount is unknown, as it's stated here, but is that something you come across?
It's something that we do for our clients whenever we do an administration, an estate administration.
So you just kind of scan all of the...
There's a Michigan unclaimed property.
And that's what this is connected to.
Yeah. And so we always do that in the administration process. And I say that term administration. This means, handling someone's affairs after they've passed.
I see.
So when we're administering the trust or administering a probate estate, we will check to see if there's any unclaimed assets that the state of Michigan is holding for this deceased person.
Right. Yeah. Yeah. It's pretty interesting, and people should do that from time to time. Go to the Michigan site is what, unclaimed?
It's unclaimed. I don't know the name of the site off the top of my head, but if you Google Michigan unclaimed assets, it'll pop up.
And the site that was named in this AARP magazine is missingmoney.com, and then from there you can get to each of the states, which is where I came up with this small amount. It looks like my dad's owed a refund by something he bought, probably on the on one of those
TV
things
come
channels.
Up. They definitely do come up.
Yeah. So we'll see what it's about. Jeffrey, believe it or not, we've come to the end of our 30 minutes.
That was fast.
Yeah. So I thank you so much for being here. Again, we thank you for joining us. Please send your ideas to here at the War Memorial for future shows, and we'll see you next time.